the final order passed by the learned single judge, my lord. And when he met with advocate on 1/12/22, my lord, then he did know the petition was dismissed. Then he approached before the legal ad, my lord, High Court legal ad on 2/12/22, my lord. From that, my lord, petitioner is advised to all the entire records of the petition, my lord. The petition record is damaged with demarc and all these and not legible in nature, my lord. That's why the main reasons to delay of filing this writ appeal, my lord.
What do you have in minutes?
My lord. My lord, petitioner was applied for the post of constable, my lord, in 2009, my lord, and finally selected on 24/24/2009, my lord. And petitioner approached first time before the High Court, my lord, learned single judge was by the impugn order passed by the department, my lord. And writ petition 8739/2009, in which the Honorable Court had directed the respondent to consider and decide the petitioner representation expeditiously in accordance with law. My lord, after that, petitioner approached to the department, and department rejected on 26 February 2010, my lord. After that, my lord, petitioner approached again to the learned single judge, my lord, before by filing the writ petition number 3039/2010, my lord, and learned single judge passed the order 26/2/2010, my lord, and Honorable Court had directed to department by order dated 4/1/2012, my lord. May I read, my lord, the order passed by the learned single judge, my lord. For the aforementioned reason, last pair of the order, my lord, the mentioned reason, the order contained in Excerpt P12, P11, 26/26/2010 is hereby quashed. The Inspector General of Police is directed to decide the representation submitted by the petitioner afresh, taking into account the fact that petitioner was acquitted in all the criminal cases in 2002 and 2003. Prior to his participation in his process of selection for the post of constable, and in the light of law laid down by the division bench of Delhi High Court in the case of Government of NCT, so needless to state that Inspector General of Police shall afford an opportunity of hearing to the petitioner and shall pass a speaking order. My lord, after this order of the Honorable Single Bench, my lord, petitioner again given a representation with the order of passed by learned single judge. Again by petitioner agreed by the department order, Excerpt P1 and P2. P1 is the order and P2 is speaking order of the department, my lord. By that order, my lord, department says that he was suppressing the material criminal antecedent in his column number 12, my lord. My lord, my case is different. The Honorable Single Judge, what he has decided in writ petition, my lord, because the order which is mentioned in impugn order, final impugn order passed by the learned single judge on 26 September, my lord, learned single judge had wrongly appreciated that I was suppressed the material antecedent, criminal antecedent in my verification form, and cited the judgment of Honorable Apex Court, Avtar Singh versus Union of India, my lord. Avtar Singh and Union of India judgment is relied only the point of verification form. I have clearly mentioned all the criminal antecedent in my form, verification form. Kindly see that my criminal antecedent relates all mentioned in my RJ2. kindly see that, my lord, document number RJ2, which is verification form I have been submitted before the department, my lord. In column number 12, I have mentioned all the criminal record which was acquitted in 2002 and 2003, my lord. Criminal case has been wrongly and falsely implicated to the petitioner, and which was Honorable Judicial Magistrate First Class has acquitted to the petitioner, my lord. I never suppress any material criminal antecedent in my verification form. Now, Avtar Singh says that, my lord, only the verification form should be filled all the facts, criminal antecedents, and the consequences which will be faced. It is in Avtar Singh, my lord, Honorable Apex Court held that employer is depend to decide whether he is entitled to get appointment or not, whether he has suppressed or he has not been suppressed in verification form. But my case is different, my lord. I have never suppressed any material criminal antecedent in my verification form, my lord. In RJ2, my lord, which has been filed along with rejoinder, my lord, verification form column 12, I have been mentioned all the criminal records, my lord. My lord, my main grounds, my lord, this is merit of the case, my lord. The citation which has been given by learned single judge in impugn order, which is different from my case, my lord. My lord, I have mentioned all the antecedent in my verification. My lord. No, my lord.
During your mentioned audit,
My lord, it is the case of the Avtar Singh, my lord. It is the case. I accept it, my lord. But I have mentioned all the criminal antecedent in my report. My lord. My lord, employer have discretion, my lord. In my impugn order at the time of single bench, my lord, P1 and P2, my lord. P1 and P2 says that, my lord, I was suppressed the material in my verification form. My lord, my case is different, my lord. Yeah, I understand. My lord, employer has a discretion whether I was. In 2002, I was acquitted, my lord. And 2009, after lapse of 6 years, जब तक हमने झूठ बोला, my lord, या कुछ गलत बात बोली, तो हम सिलेक्शन में थे, my lord. I was meritorious. जब हमने सारा वेरिफिकेशन फॉर्म में लिख दिया, my lord, तो I was not selected in that point, my lord. हम अपराधी हो गए मैलॉर्ड, डिपार्टमेंट ने हमको अपराधी घोषित कर दिया मैलॉर्ड। ये स्टिग्मा हो गया मैलॉर्ड हमारे लिए।
This is the appeal against the order passed by learned single judge. Matter pertains to the appointment of Anganwadi worker. Respondent number 7 did not submitted any document with regard to belonging her in the BPL category. Collector and commissioner consider the matter, and my appeal was accepted by the collector. In para 14 of the order, you kindly see, at page 15, para 14 of the order. The benefit of the document which was given, that does not belong to the father of private respondent number 7. That belongs to someone else. Respondent number 7 never submitted any document with regard to belonging her in the BPL category. Let me kindly consider annexure P7 filed by the petitioner. P7 at page 26 of the petition, main petition. Serial number 11. जिस BPL का इनको बेनिफिट दिया जा रहा है, that belongs to one Munnilal Gorelal. It does not belongs to the father of private respondent number 7. But learned single bench, giving the benefit of this particular BPL number. This does not belong to the father of respondent number 7. और इन्होंने वहां पर एप्लीकेशन के साथ कोई डॉक्यूमेंट भी नहीं फाइल किया. डिजर्टेड का पॉइंट नहीं दिया, इनको बीपीएल का दिया.
There are two terms on which they challenge. One is that she was considered to be a deserted. The other is that she was not entitled to the BPL marks because her name was nor her husband's name was in any BPL card. He was a government servant.
Para 14 of the order.
Marks allotted on account of BPL were not correct. They were, in fact, even in the column where the application is submitted, Hence, the BPL card she has ticked it as a cross, which indicates that there was no BPL. For BPL, she was learned single judges held that she is entitled to the BPL marks.
No, my lord. No.
Not in the name of her husband because he was a government servant. He was a forest state guard. And she cannot get the that is the learned commissioner and collector have passed an order in favor of the
Appellant.
holding that the private respondent number 7 in the writ petition was not entitled to the BPL marks.
My lord, kindly see page number 36, collector साहब का order है my lord. Page number 36, my lord. My lord, may I read my lord? My lord. दावा आपत्ति उमा कांवरे का चयन उसकी मां के बीपीएल क्रमांक 1 का अंक देकर चयन किया गया है. इसका निष्कर्ष निकला my lord निराकरण. आपत्तिकर्ता गीता सिंह द्वारा आपत्ति की गई कि उमा कांवरे को उसके मां के बीपीएल क्रमांक 11 का अंक देकर चयन किया गया, जबकि उसकी मां पुरुष एक कार्यकर्ता पद पर पदस्थ है एवं उसके पति वनरक्षक पद पर पदस्थ है एवं वह अन्य ग्राम की निवासी है. दूसरा आपत्ति आई महिला चयनित की गई मां कार्यकर्ता पद पर पदस्थ है एवं उसके पति अशोक कुमार वनरक्षक पद पर पदस्थ हैं. इसका निष्कर्ष है महिला जिला स्तरीय समिति द्वारा निर्णय में चयनित उमा कांवरे द्वारा प्रस्तुत निवास जिसमें ग्राम कोडार का निवासी है, बीपीएल में उमा कांवरे का नाम दर्ज है एवं उमा कांवरे द्वारा शपथ पत्र जिसमें पति द्वारा 2016 में छोड़ दिया गया, जिसमें परित्यक्ता के 10 अंक देने का प्रावधान है जो नहीं दिए गए हैं, फिर भी उमा कांवरे प्रथम स्थान की वरीयता रखती है. अतः आपत्ति अमान्य करते उमा कांवरे का चयन अनुमोदित किया जाता है. महिला माँ इसकी मुन्नी बाई उमा कांवरे की बीपीएल धारी है और उसको बीपीएल के 10 अंक दिए गए हैं. अभी प्रश्न आता है कि उसको है महिला जी बिल्कुल P7 लगा हुआ है, उसको एक्सेप्ट किया गया. यदि नहीं होता तो जिला स्तरीय कमेटी महिला कैसे कंसीडर करती है उसको P7? और जैसे उन्होंने बताया कि उस पिता का नाम नहीं है तो महिला उसमें पिता का नाम चलता है, मुन्नी देवी पिता गोरेलाल. मुन्नी देवी हमारी मां है और यदि वो नहीं होता तो जिला स्तरीय कमेटी महिला कंसीडर ही नहीं करती वो इस पॉइंट के लिए. और हमको वो परित्यक्ता 10 अंक नहीं दिए गए, फिर भी हमारे ज्यादा अंक पाएगा, इसलिए हमारा चयन किया गया है. कैंडिडेट P1. एक P7 महिला पेज नंबर तो मदर का ही चलता है महिला, मदर या फादर का चलता है, उसका इंडिविजुअल उसका तो होगा नहीं, क्योंकि परिवार का चलता है. तो बीपीएल कार्ड महिला इंडिविजुअल उसका नहीं आएगा, तो उसका बीपीएल लड़की का आएगा महिला.
Yes, my lord.
Yes, it has. If it is, if she's living with her, yes, for me, if she's living with her parents, it should contain her name. Oh, she is married.
और इसके फादर का भी नाम नहीं.
इसका मतलब शादी हो गई 2016 में छोड़ दिया गया हमको. हम 2016 तो मदर का हमको लाभ दिया गया है कि जो मदर का नाम है हमारा उस बीपीएल कार्ड में, और चूंकि किसी भी लड़की का मतलब 2 ही होम होती है, या तो पति का होगा या पिता का होगा महिला.
You only school that at that, they are Anganwadi workers. Somebody is required to be posted there.
Order passed by the collector and commissioner in my favor, my lord. Can my lord any date may kindly be given, my lord?
Well, there are delays filing the appeal. There are delays. My lord. Merits, my lord, by the impugned order, my lord, our claim in respect of the declaration of the Misa detainee has been rejected, contrary to the rules, my lord. May I read, my lord? Page number 14, impugned order. No, my lord, they are saying, my lord, kindly see the rule, my lord. They, in one hand, they are saying, my lord, no record is available, my lord. In other hand, my lord, we have seen the report, my lord. Neither the kindly appreciate my kindly appreciate the rules, my lord. 4.1, page number 24 of the writ petition. उक्त एनेक्सर P2 उक्त नियम में नियम 4 में निम्नानुसार संशोधन एवं प्रावधान जोड़ा जाए, अर्थात जहां जेल, पुलिस थाना तथा जिला मजिस्ट्रेट का निरुद्ध संबंधी शासकीय रिकॉर्ड उपलब्ध नहीं है, केवल उन्हीं प्रकरणों में आवेदक के साथ जेल में निरुद्ध रहे किन्हीं 2 मीसा/DIR के अधीन राजनीतिक एवं सामाजिक कारणों के निरुद्ध व्यक्तियों की शपथ That's why we have submitted. But
It is not there.
in that register, my name is not there, my lord. But 2 persons are giving the affidavits, my lord, as per the rules. One. They are the Misa detainee. They are giving the affidavit as per the rules, my lord. Yes.
This is the PIL, my lord, wherein the question with regard to is it where the petitioner is raising a road which was already been constructed 2 months prior to this, my lord, is now NIT is being issued for construction, my lord. A road which was already been constructed just 2 months before by a private person, my lord, in order to obtain a forged permission from TNCP. Again, an NIT in order to save him was issued, my lord. Annexure P6 is the NIT.
1 to 7, my lord.
Lord, in this case, the P1 is impugned order, Lord, whereby my candidature for appointment of on the post of assistant professor is cancelled, my lord. Page 17 is the order. Lord, it does not speak anything, my lord. It says only, my lord, the candidature is cancelled, my lord. The page 18 is, my lord, the order containing at page 18, my lord. It says, my lord, that समिति द्वारा प्रकरण में अनुशंसा नहीं की गई है. Means, my lord, there was no decision by the committee with respect to me. However, the same column 3 says, my lord, that नेट परीक्षा वाणिज्य विषय के सह विषय प्रबंधन मैनेजमेंट में उत्तीर्ण की है. अभ्यर्थी द्वारा उत्तीर्ण एमबीए अंतिम वर्ष तृतीय वर्ष चतुर्थ सेमेस्टर में सह विषय से संबंधित मुख्य विषय नहीं है. अतः प्रथम एवं द्वितीय सेमेस्टर की अंकसूची परीक्षण प्रस्तावित है. Lord, without issuing, Lord, any so cause notice, Lord, this decision is taken. My lord. Lord, Lord, I am having what they are saying, Lord, that मैनेजमेंट एमबीए की तृतीय एवं चतुर्थ सेमेस्टर में सह विषय से संबंधित मुख्य विषय नहीं है. अतः प्रथम वर्ष द्वितीय वर्ष सेमेस्टर की अंकसूची. No. Kindly appreciate, Lord. I again read, Lord. What they are creating the confusion that it is not clearly mentioned in the mark sheet. I have passed, Lord, though they are admitting, Lord, that I am having eligibility criteria, but it is not mentioned in the mark sheet. Kindly see, Lord, the mark sheet, Lord, which will clear. Because the different universities are adopting, Lord, the different criteria for mentioning, Lord. It is page 31. My mark sheet, Lord. Subject code is given. Therefore, Lord, they are drawing conclusion. Subject code is, Lord, MBA 21, MBA 22, MBA 23. And the university has prepared, Lord, the syllabus in which also, Lord, the subject code is given. That I have filed, Lord. From where I, Lord, obtained, Lord, this degree. And appreciate, Lord, page 77 and 78. Relevant subject is, Lord, MBA is required, Lord.
HR.
MBA HR. So
HR, human resource.
yes, because HR is not mentioned in the mark sheet, Lord. Therefore, Lord, confusion is created, Lord. MBA, just I referred, Lord. Kindly appreciate, Lord. Lord, what I want to demonstrate, Lord. I have cleared my master degree in MBA from HR, Lord. Therefore, I am, Lord, implemented respondent also university. And the only because, Lord, the HR is not mentioned in the mark sheet, human resource. However, Lord, the subject is MBA. HR. Kindly see, Lord, which I have filed, Lord, this syllabus of the university. नहीं तो सब्जेक्ट कोड लिख रहा है ना, इसी कारण से तो कंफ्यूजन हो रहा है. सब्जेक्ट कोड की नहीं सब्जेक्ट कोड नहीं लिखा होने की वजह से Lord, if the notices are issued by the Lord, them, Lord, to me, Lord, I could have, Lord, explained the entire things, Lord. Number one. Number two, my Lord, Lord, the university has, Lord, mentioned only code, Lord, subject code. Lord, HR is not mentioned. They are saying, Lord. So, Lord, I may be permitted, Lord, to rely, Lord, this judgment, which says, Lord, that they cannot, Lord, reject my candidature in, Lord, in an arbitrary manner, Lord. This is, Lord. नहीं नहीं ह्यूमन रिसोर्स में है केवल सब्जेक्ट कोड लिखा है, इस HR नहीं लिखा है उसमें, इस कारण से कंफ्यूजन हो रहा है सर। दिस इज मिलोड ILR 2021 MP मिलोड 2092 para 17 and 18 मिलोड that is मिलोड by yes Shailesh Kumar मिलोड 17 and 18 and मिलोड thereafter in civil appeal 6668 of 23 also मिलोड।
The contract for housekeeping services was awarded, my lord, to the petitioner in July 23, my lord. That contract was for 1 year, my lord. Within 4 months, the contract has been terminated by an Annexure P4, my lord. That is page 44, my lord. Pointing out certain shortcomings in the performance of the work and the allegation that I was not paying wages to the workers. My lord, in response to their notice, I duly. But the termination is not tenable on the face of the record, my lord, because I had been paying wages to the workers, albeit with delay, my lord, and I yes. But it is having some civil consequences also, because they say that it's there, my lord, but the way in which they have terminated this contract, my lord, it's not proper, my lord. And they are going to award the work to some other. If my lords are not inclined, I may be given liberty, my lord, to approach the other forum, my lord.
The petitioners are guest lecturer of respondent department presently posted in the office of respondent number 4 is seeking direction against the respondent number 4 who has failed to implement the government order Annexure P7 issued on 5th of 10, 2023 by which government has taken decision to enhance the remuneration of the employees appointed like petitioners. And this order P7, page number 46, has
Identical petitions are pending before your lordship.
Lordship, the other in various districts have already implemented the order. They have extended the benefit. I have filed those orders in Annexure P9. There is no reason to withhold the right and claim of the petitioner despite the order issued by the government of Madhya Pradesh, Lordship. So therefore, they may be directed to implement the P7 order. But any big commenting maybe?
My lords, I seek permission to withdraw this petition and file a fresh, my lord. There's with liberty to file a fresh. Much obliged, lordships. Much obliged.
Lordship.
Identical, Lordship, identical matter is already pending before the Honorable Court. So my humble submission is that please link this petition with 15150 of 2023.
माइलर लैंड एक्विजिशन से संबंधित मामला है। कटनी डिस्ट्रिक्ट में 100 स्क्वायर फीट की भूमि गलत तरीके से एक्वायर की गई है। सर इन्हें सर बगैर किसी सुनवाई नोटिस दिए ने एक्वायर की है। पहले हमने इसमें आपत्ति की थी जब इन्हें नोटिफिकेशन निकाला कि नेशनल हाईवे नंबर 7 के लिए इसको एक्वायर की जाना है, वो पूरे एरिया की भूमि, तो हमने आपत्ति लगाई, उसमें हमारी आपत्ति निरस्त कर दी गई। इसके बाद हमने हाई कोर्ट में पिटीशन लगाई। हाई कोर्ट ने हमको रेवेन्यू ऑफिसर के सामने, टर्मिनल के सामने, कमिश्नर रेवेन्यू उनके सामने जाने को बोला। कमिश्नर रेवेन्यू ने ऑर्डर किया कि सक्षम अधिकारी के सामने आप जाएं, वो उसका मुआवजा निर्धारित करें। उन्होंने आज की तारीख तक कोई मुआवजा निर्धारित नहीं किया और जमीन एक्वायर कर ली। नहीं, उन्हें हमारी बार अलग कर दिया सर उसमें से। सर पूरे 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 गांव की जो थी, वो पूरे ग्राम पंचायत की पूरी के लिए उन्हें नोटिफिकेशन निकाला था, उसमें हमारी थी। जी, मैंने उन्हें पूरी जमीन के लिए निकाला। जी, पेज नंबर 30 माइलर। पैरा नंबर 2 माइलर। खसरा नंबर 137 में श्रीमती अर्चना नागरिया का नाम भूमि स्वामी में अभिलेखों की कैफियत कॉलम में उल्लिखित है, अतः खसरा नंबर 137 के स्वामित्व के अभिलेखों का परीक्षण करने की अवधि तक भुगतान सुरक्षित रखा जावे। मतलब एक टाइम में मंडे के लिए नोटिफिकेशन लगा देते, अभी खसरा लगाया हुआ है माइलर।
माइलर इसमें ये है कि हमारे यहाँ जो लैंड है, मैं परमिशन चाहती हूँ माइलर इसमें। मेरी लैंड का उन्होंने इसमें लिखा जरूर है कि हमने एक्वायर किया, परंतु ना उसको एक्वायर करने का बोल रहे हैं कि हमने एक्वायर किया और ना ही वो किया। नोटिफिकेशन में माइलर उन्होंने खसरा नंबर 137 दिया है और हमारी लैंड 137/1 है, क्योंकि छोटा सा हिस्सा है उसका। नोटिफिकेशन की कॉपी नहीं लगाए माइलर, ये जो ऑर्डर है इसी में इन्होंने पूरे नंबर इन्होंने मेंशन किए हैं, जो जो इन्होंने वो किया है। जो जो नंबर इन्हें एक्वायर किया वो नंबर लिखे हैं। यस मैडम, उन्होंने मतलब उन्होंने वहां पे एक्वायर कर लिया है और वो बोल रहे हैं कि हमने ले लिया, हमने मुआवजा दे दिया। मतलब जो ये जजमेंट लिखा है इसमें लिखा हुआ है मतलब लैंड तो हमारी कब्जा ले लिया 22 में उन्होंने कब्जा ले लिया है। मतलब ऐसा डायरेक्शन उसमें होता है कि हमारा लैंड एक्विजिशन के उसमें नहीं आता है। वो कह रहे हैं कि हमने ले लिया है, हमारा कब्जा कर लिया, उन्हें जो खसरा हमको अभी बात का हो रहा है उसमें लिख रहे हैं वो। मतलब नोटिफिकेशन की कॉपी मैंने निकाला नहीं था, उसको मैं आपके पास 137(1) नहीं लिखा उनने। टाइम दे दीजिए मुझे उसमें, या मैं बेटा करके उसमें फाइल कर देती हूँ। नोटिफिकेशन में बटे नहीं लिखा है भाई लोग, और मेरी लैंड जो है मेरा ओनरशिप है, वहां पे खसरे में एंट्री है, सब है। कब्जे में उन्होंने खसरे में जहां मेरी एंट्री है वहां पे उन्होंने लिख दिया है कि लैंड एक्विजिशन। हाँ, बेचा कब्जा किया उन्होंने, मैंने लिखा है कि नेशनल हाईवे, हाँ अतिक्रमण किया है उन्होंने। नेशनल हाईवे वालों ने किया है तो सिविल कोर्ट पे कैसे? मतलब जो डायरेक्शन दिए हुए हैं पहले भी, जो एनेक्चर P5 में दिया हुआ है डायरेक्शन कि इनका बाद में डिसाइड करेंगे, और P7 जो कमिश्नर का ऑर्डर है उसमें भी डायरेक्शन दिया हुआ है कि इनका डिसाइड करें, और उन्होंने अभी तक नहीं किया है।
टाइम दे दें, पहले 2 वीक्स टाइम दे दें।
मतलब 137 दिया है, अगर उसको मान रहे हैं तो माने जाएगा।
टाइम देते हैं नोटिफिकेशन सर्च करने के लिए,
नोटिफिकेशन सर्च करके उसको
पहले 2 वीक्स का टाइम दे दें, कोशिश करते हैं नोटिफिकेशन निकालने की।
मतलब नेशनल हाईवे में अगर सिविल कोर्ट में हम जाएंगे तो नेशनल हाईवे के केसेस में वो मानेंगे नहीं, आप उस प्रकार चीजों का लिबर्टी दे दीजिए सिविल कोर्ट में उसमें जाने के लिए। थैंक यू।
Respondents have not considered his request for continuation of the service. He's a guest teacher, my lord. The ground that on which they have not considered my request is that in the previous academic year, I have failed to achieve more than 30% of the result. The situation in this school which I am teaching is that there was only one student in the 12th class, and she was promoted generally because of the my lord, but there was only one student, my lord, and that too, she has, my lord, she was promoted generally during the COVID. Grateful.
My lord, in this case, the petitioners are seeking direction to decide their presentation. My lord, what happened in this case? My lord, in the year 2014, the land of the petitioners was acquired for the purpose of construction of national highway. My lord, what happened in this case? My lord, my lord, for the grant of solicium. My lord, in the
It has already been decided by the competent officer.
my lord, in other cases.
Page 87.
My lord,
The claims have been found to be valid and it has been.
my lord, in the case of identical persons of the same village, the claim has been decided, but our claim is pending.
We'll decide on upon that. Decide.
But my technical bid, my lord, has been rejected, my lord, and the order, my lord, is at page 127. The ground, my lord, for refusing my technical evaluation, my lord, is on the ground that there are 3 directors in the company. And the board resolution, my lord, authorizing, my lord, is by 2 directors, one authorizing the other. Page 127, my lord. It says number of directors described in the appendix are 3, namely such and such. Lord, Lord, if your Lordship may have, my Lord, Section 174 of the Companies Act as well as Section 103, it says, my Lord, the minimum directors required, my Lord, would be 2 now, or 1/3. Now here, my Lord, they admittedly 3 directors, my Lord. 2 are there, my Lord, in the minutes of the meeting, and 1 is authorizing the other. Only 1 director is absent. Now, despite that, my Lord, the mandate of law is 2 or 1/3. I've also quoted, my Lord, Section 103 in para 6.4 of my petition of the Companies Act. The total directors are 3, 2 are present, my Lord, and the other person is authorized. Lord, if your Lordship would have para 6.4, I've quoted, my Lord, 103. It says the quorum for meeting of a board of directors of the company shall be 1/3 of its total strength or 2 directors, whichever is higher. And the participation of the directors by video conferencing, my Lord, that's not relevant. So the quorum has to be, my Lord, either has to be, my Lord, 1/3 or total strength, my Lord, has to be whichever is higher. So in our case, admittedly, there are 3 directors, 2 are participating, my Lord, and 1 of them, my Lord, has been authorized to sign, my Lord, the tender documents. Same, my Lord, is the import of Section 174 of the Companies Act as well. We gave a representation, my Lord. Mechanically, that has been rejected. P6 at page 135. Much obliged.
Lordship, may I place on record our additional affidavit? In this case, what has happened is the matter that is limited before your Lordship now is with regard to the interest on the delayed payment. The MPRDC had given an amount of rupees 5,83,909. The land acquisition officer has approved of this demand and has conveyed it to the MPRDC that the payment may be made. The MPRDC had reverted that the requisite documents be collected and forwarded to the MPRDC for further. Within 1 week, we'll collect all the documents of the. I'm just kidding. Within 1 week, we'll forward all the documents to the MPRDC. Thereafter, from our end, the process will be over. The payments will be. Well, 1 week's time that I'm paying for is on a larger side. Within 2 or 3. Well, it's well, it's as far as the earlier. Well, as far as the delayed payment is concerned, we had filed a reply and we have stated that earlier reply.
निवेदन था मतलब उन्होंने जो उनका कहना है कि हमको दे रहे हैं मतलब 5,83,000, जबकि मतलब हमारा जो है 11/2/2022 तक में मतलब हमारा जो होना चाहिए 8,43,000 है मतलब हमारा पेमेंट टाइम दे दिया जाए मैं टाइम दे दे मैं हमारा पेमेंट करा देने भुगतान नहीं होगा मेरा.
We have responded like 3. Before.
Wait, please. This matter concerns, they filed a PIL regarding certain issues regarding forest dwellers. We had filed a reply in 21, the detailed reply, but there's some matters pending at the Supreme Court also. With regard to the current status of the claims of the forest dwellers which were dealt and rejected, and
let them furnish the latest information. In the meanwhile, we are also collecting. We had sought some time to file rejoinder. The data is not with us completely. So far as one district is concerned, state in its return itself has admitted that more than 36,000 such claims which were rejected have been looked into. What they have done till that they can, that will show that the act has been functioning well or not. Our main grievance is that they have made it very technical to be lodged on a portal. Earlier on, it was Gram Sabha which was doing it, and Gram Sabha knew everybody was residing.
Clarified that, Manoj. I'll put that also. In this, Manoj, they filed this petition as a PIL, Manoj. The person had, Manoj, the staff had died during COVID during election period, by election of Damo, Manoj.
Petition is not.
Madam.
Lord, here my contract, my lord, was terminated, my lord, by an incompetent authority, by order dated 6/9, my lord. Notices were issued to the respondent and an interim relief was granted in my favor. That the 6/9. My lord, what happened was, my lord, because the counsel was not from Jabalpur, my lord, the case got dismissed. It was restored, but the interim relief was not restored. So we moved an IA, my lord.
We are moving. Which is the I.
We're moving this IA, my lord, for continuation of interim relief, my lord. We executed a contract, my lord, a part of. I prefer such a call.
Look, in this case, Malal, last date of hearing, court has directed to respondent to comply with the order, Malal.
But I may be permitted to pass on the document. The issue was pertaining to the grant of interest, my lord, on the limited payment of award. And what would be the date for the computation of interest, my lord? Whether the date of, from the date where the award was passed or from the date of acquisition. My lord, the state, my lord, I have been communicated this order, my lord, that they have, the state has, the award, the interest is to be calculated from the date of acquisition, that is 2014. The demand has been sent, my lord. And the total interest which is to be paid is 3,45,000, my lord. Lord, we have paid for 10 days time, my lord, because the demand has been raised and National Highway Authority will release the payments. We will make it. This is only in respect of interest, my lord. The rest all is paid. Lord, this says, my lord, this is within 10 days we'll do it. This letter itself says, my lord, it's dated to the
Malal.
This is the nursing matter bunch. On 20th of September, your lordships were pleased to grant 3 months time to CBI to conclude the inspection of colleges and submit the report. So from 20th September, my lord, it's already 3.5 months as on date, my lord. My lord, this was the case where we are praying, my lord, that the colleges which have already been cleared by the CBI, their results withheld since last 2-3 years should be declared, my lord, at least. And lordships had indicated that your lordship would not like to do it in a piecemeal and let the entire inquiry by the CBI and inspection be done. And after everything is done, lordship was of the view that we will consider which colleges are clear and which are not, my lord. My lord, that basic order, my lord, is in item 28.19. That is, my lord, 4847 of 23, my lord. One Dilip Kumar Sharma is the basic order. All other cases are linked along with that. In 4847, my lord, 20th September, Lordships, while my lord recording the state submission that they will provide adequate support, and after considering, my lord, that the students' future is at stake, Lordships were pleased to, my lord, record the submission of CBI that they will furnish a report in 3 months' time, my lord. By then, my lord, nearly 60% colleges had already been inspected about. The Lordships had indicated that let entire exercise be complete, then Lordship may consider, my lord, which colleges have actually been cleared by CBI so that.
My lord, the report is with me, my lord. My lord,
Complete.
my lord, may I say something? My lord, it's a report for about 254 colleges, my lord. Out of 364, 50 are protected by Supreme Court order, and about 55 colleges are left. My lord. My lord. 55. 55. कब करेंगे कब?
Sir, within this one, they will be completed.
No, no. 55 colleges are this month, within month.
Sir, our teams are still there.
Yes, yes, yes.
Our information is, my lord, about 5 to 6 teams of CBI are spread out, my lord, throughout the state inspecting colleges. Even one team, one college per day, my lord, they will finish in 2 weeks' time, my lord. This is what I was trying to say to you. Lord, they may, my lord, but then the ground reality is, my lord, they have already constituted 5-6 teams. They are all spread out during the throughout the state, my lord.
6 55 colleges left.
Seventy colleges.
Total. Small submission. On the in the order of 20th September, we have been ordered to inspect about duplicate faculty also, my lord. That aspect we have not yet taken, my lord. We could not take. My lord, that we are not in a position. My lord, we are not in a position. We are trying very hard, my lord. We are doing everything, my lord.
My lord, I have a lot of respect in submission. My lord, I have
Yes. Actually, we could not do our. बाकी भी हम नहीं कर. Yes.
50,000.
My lord, I have a respectful submission. My lord. More than 61,000 students in different academic sessions. They are waiting for their result. They have appeared in the examinations in different academic sessions. They are undergoing severe mental trauma. Now they are making serious complaints to the CM helpline that they would take some harsh step against their own self. So, Malad, we are very conscious about it, Malad. My respectful submission is, Malad, if these matters will be taken up in the next week, by that time, Malad, the report which is already furnished by the CBI, that may kindly be examined, Malad. We'll come out with an application. In the next week, could it be taken up, Malad? Because we'll
not order this.
Yes, sir.
Disrespect.
Yes, sir. Yes.
Lord, we file appropriate application, Lord, could it be taken up in the next week, Lord, these matters? Lord? We make a request, Lord. Yeah, I'm sorry. I'm sorry.
Lord, can I make a like?
I'm sorry.
Can I make a prayer, my lord? My case is item number 28.9. It's a different matter. It's a disciplinary case, my lord, has been linked with these matters. 28.9, my lords. May kindly be dealing one.
Great. Lordship, I am paying for item number 28.8. It is also a different matter. Or input. Or let's say request. But it be taken up on the 17th instead of the 18th.
Yeah.
May 17.
My lord,
My lords, we won't be here on 17. I'm not here on 17. If it is.
Sorry.
my lord, if I may, my lord, 28.28 with regards to different thing, my lord, there is no challenge to the affiliation, my lord. It has stopped the results, my lord. 28, my lord. I am for the intervener, my lord. It is with regards to nursing college itself, my lord. Let me clear it, my lord. But it is with regards to stoppage of the entrance exam, my lord.
My lord, 28.3 is also different matter.
Your Lordship, 28.1 and 4, Your Lordship.
My lord,
Oblige, sir.
my lord, if a date may be given in 28.28, my lord.
My lord, 28.51 is also a different matter.
My lord, there's a stay order. That's why I say that a fixed date be given, my lord. Then, my lord, it may be kept linked with this case, my lord.
Lordship, the arguing counsel wants to appear through VC mode.
Yes, who's appearing?
My lord, I'm appearing on behalf of the appellant.
Yes.
My lord, on the last date of hearing, I had filed an amendment application. The respondent had taken time to file the reply for the same.
Yes. Comment?
In this amendment application, they have, though we will not oppose to the
Are
amendment.
you opposing or you want time, mister? We are not here to sit and listen to your stories.
500 lakh to the
How much time you want?
2 weeks.
2 weeks finally to reply to the IA filed by the appellant.
Highly obliged, your lordships.
The state is seeking time, my lord, to file the response. This is the matter, my lord, where the challenging, my lord, the grant of lease in an illegal manner. And because of, my lord, the incorrect map, certain government lands and the private lands are involved. That incorrect map was already sought to be corrected by the revenue authorities. Yes. And they sought time to file the response to that matter.
Additional return is required. But after return, the stay was granted, so
Yes.
additional return is required. After
The aspect, my lord, the manner in which, my lord, the grant was made, they need to explain for their reply.
document taken on record filed by the petition.
नहीं, हमने तो
In fact, Maharaj, this is the third time of litigation where without declare this said
Stay लगाओ ना, make it of stay.
get.
On the last date of hearing, your lordship were pleased to grant an interim order in my favor. It is now to be heard finally. My lord, in this I'm seeking a week's time, my lord. Reply from union and university is on record, my lord. They say this pertains to scholarship, my lord, and other benefits to disabled person in Dr. Hari Singh Gaur University in Sagar, my lord. Their reply is on record, my lord. My lords, we are filing an additional reply of your option. In this case, the petitioner has been continued to, who is a guest faculty, has been continued to the age of 65 minutes. In our additional reply, we are filing that. And the balance of the payment that is to be remitted has already been remitted, my lords. We are filing the document to that effect also. A copy of the reply has been filed. Yes, my lords, we have paid all
But Lordship, I have not received the copy today. Lordship, I examined the as per court order in contempt as filed replied remaining 10 months as payment not made. So I have examined then.
My lord, yes, my lords, in our, my lords, in our additional reply.
तुम पकड़ के रखते हो तो हमें कैसा पढ़ना है?
I apologize, your lordship. Yes, my lords. Yeah. My lords, para number 5. Only with regard to July 22, the payment.
No, Lordship, I have not received the payment of the 2020-21 5 months in 22-23. But I am continue February to July. But he is not make a payment, Lordship.
We have stated that we have not made the payment of July 22 since in this particular month he did not discharge.
Yes, I have joined the school and
August, October,
performed the duty during the COVID period, Lordship.
Minutes R8, maybe see, Aniksha. This is with regard to the payment minutes. July 22, since he did not discharge his duty, the payment was not made. Thereafter, all the payments have been made.
No, Lordship. In date of order dated 2/2/2021, Lordship, I continue perform the duty. But Lordship, can't say P3 PS21 writ petition as per Honorable Court order, I have join and continue the work. Page 28 writ petition, Lordship. After that, I will join Lordship. And then I have filed a contempt petition as per compliance report, Lordship, page 30. कि पेमेंट सेंशन हो गया, इसको हम ग्रांट कर रहे हैं, पेमेंट कर रहे हैं और कंटेम्प्ट पिटीशन इज ड्रॉप आउट. बट फाइल द रिप्लाई की इस पीरियड पे ये अपन पर लॉर्डशिप आई एम let me examine Lordship as per reply. Recently I have received the copy and examine and submit the proofs and documents, Lordship. I load well, Lordship.
The last opportunity, Lord, I'm praying for time, Lord.
2022 petition, Lordship. Lordship, in this case, Lordship, the petitioner is the mining businessman, Lordship.
Refund of dead rent.
Refund of dead rent, excess dead rent, Lordship. Lordship, in the Lordship, kindly see the page number 38, P7. The Karala collector. In second para, Lordship. They have admitted, Lordship, that they access, Lordship. Lordship, my case, petitioner is a mining businessman, Lordship. He deposited excess dead rent, and the authority is admitted, Lordship, that 2 lakh रुपए इसको adjust करना है. But Lord.
May please, Your Lordship. Your Lordship, there's a delay of 190 days, minutes. However, there was a review that was filed against the order of the Honorable Single Judge. Millers, that respondents appeared in the last report. Millers, we are challenging the order dated 5/7/22 and 4/3/22, Miller. By these orders, Millers, the petitioner had been it has. Yes, Millers, in a number of cases, Your Lordship. However, Millers, Your Lordships have also decided a couple of matters wherein my lords have held that if a relative of a government servant is under government job, Millers, he is not entitled to the. Yes, my lords. My lords have decided directing for holding of an inquiry.
And the response is awaited. Twice they have taken a time to file.
Lord, I'm praying for time. Twice, my Lord, we have taken time. For 3 weeks time. 2 weeks time.
Obliged.
I get it. Definitely. But we'll get it on the time. Well, it's
Lordship, last occasion, there was a question. That is a matter pertains for the 4A of the Public MP Gambling Act, Lordship. They have registered the FIR. And the issue involved in this present petition, whether the offense under section 4A is cognizable or non-cognizable. So since the respondent filed the reply, Lordship, and last occasion, Lord, my Lord has directed to state to file an additional reply or whatever may be, so that this issue can be resolved. In respect of 155(2) of the CRPC, they have required to seek a permission from the concerning magistrate. Yes, sir. The FIR that made Lordship. There is no any such instrument. FIR is the page 11, Lordship. मैं थाना 29 उपनिरीक्षक पद पर पदस्थ हूँ इमरोज दिनांक 19/5/2022 को क्राइम ब्रांच की सहायक धनंजय द्वारा मोबाइल पर ऑनलाइन T20 का मैच में रुपए का दाव पेज खिलाते पाए जाने पर आरोपी नितिन विश्वकर्मा पिता विनोद का सो मोबाइल से गुरु कृपा ऑनलाइन बुक की लिंक स्क्रीन में सट्टे का दाव लगाते हुए मिलने पर थाने लाकर पेश किया, जिसके बताए अनुसार साहिब रेस्टोरेंट के पास IPL का मोबाइल से रुपये पैसों का दाव लगाकर सट्टा खेल रहा था, जिसने बताया कि 2 अन्य लड़के भी मोबाइल T20 मैच का सट्टा खेल रहे हैं। तस्दीक वास्ते हमरा सो रवाना हुए थे। मौके में नितिन विश्वकर्मा को लेकर साहिब रेस्टोरेंट पहुंचे, जहां पर बाहर एक मोटरसाइकिल क्रमांक MP20 पल्सर खड़ी मिली, जिसके पास 2 लड़के मिले जो मोबाइल एवं लैपटॉप पर दहल चौक के पास पट्टी पर बैठकर मोबाइल चला रहे थे, जिनके नाम पता पूछने पर एक ने अपना नाम अनुराग त्रिपाठी तथा पिता सो तथा थाना लड़कर एवं दूसरे ने अपना अक्षय विश्वकर्मा सो मोहगांव कोतवाली बताया। दोनों तलाशी लेने पर एक वाईफाई से जुड़े मोबाइल मिले, जिसमें 4 नार्जो कंपनी का मोबाइल, 2 आईफोन कंपनी का मोबाइल, 2 रियल कंपनी का मोबाइल, 2 वीवो कंपनी का मोबाइल, 1 ओप्पो कंपनी का मोबाइल एवं 2 डेल कंपनी के लैपटॉप, 1 चार्जर डेल कंपनी, एक एक्सटेंशन बोर्ड, 1 डार्ट कंपनी का चार्ज, एक MI कंपनी का चार्जर, 1 एप्पल कंपनी का चार्जर, 1 पावर बैंक, MI कंपनी का 2 माउस।
He was he was involved in betting by use of his mobile phones on Millers. During the course of investigation, that material was collected, Millers. Millers, the charge sheet has been filed, Millers.
In charge sheet, only allegation, only okay, sorry.
Miller's statements have been recorded in the charge sheet which Miller's, if I could read the statements, in the statement it has come out. Miller's the 161, Miller's as far as the technical information is concerned, Miller's, we have sent the laptops and mobiles that were recovered for that for FSL reports. Miller's, that report is awaited.
How can the report be awaited when you have already filed charge?
As for the statement of recorded under 161, Miller's, prima facie, Miller's, with utmost respect, Miller's, at this juncture, Miller's, with utmost respect, Miller's, the statement
In fact, even this
161 statement. Several 161 statements were recorded. The charge sheet has been filed. He has filed the charge sheet. He has filed. Miller's, it has been sent to the cyber forensic lab. Miller's, the report is awaited.
Lordship,
No, Miller's,
no,
it has been
we
released.
have granted bail because bail.
Immediately after
Lordship,
arrest under section 40, he was released.
Lordship, we filed a supurnama April to May, Lordship. That was dismissed by the trial court. They have observed that since the forensic report is not in the charge sheet, therefore they cannot help us. Therefore, we file a revision. Revision is also pending because they gave a statement in the month of July. Question. Yes, sir. Yes, sir. And one more submission, Lordship. Last submission.
Miller's. We have Miller's, we have sent the mobile to the state forensic state cyber forensic.
One
Miller's with regard to the
Lordship, one more submission. Kindly see that their reply, Lordship. They have said that not below rank of the DYSP, the FIR cannot be lodged. The sub-inspector. Yes. Mobilized. Yes, sir. Yes. Mobilized.
Miller's, since it was a writ appeal, Miller's, we have submissions. State cyber forensic lab. Miller's, 2 weeks time may be granted. We'll call for that.
Bill.
Actually, we were directed to file reply in this matter. I'm praying for 2 weeks' time to. So the matter in respect of the order of termination passed in the case of Gram Rojgar Sahayak. We should 2 weeks' time.
Lord, this matter pertains to appointment on the post of my lord BAC on the basis of my lord deputation.
We have filed.
Reply has been filed, my lord. My lord, state government, my lord, issued a policy for appointment on the post of my lord BAC. And as per the policy, my lord, the upper division teachers has to be, my lord, secured position over the, my lord, Madhyamik Shikshak. We are, my lord, upper division teacher. But the, my lord, authority has issued the, my lord, seniority list in which, my lord, the Madhyamik teachers have been found over the petitioner. Therefore, my lord, we filed earlier a petition before this honorable court. That was disposed of to submit a representation before the collector and also made application for interim stay before the collector. And collector may decide the, my lord, my representation. The collector, my lord, not decided my representation. He, my lord, published the final select list. Final select list, I have been challenged before the, my lord, writ court. And my writ petition has been dismissed without, my lord, yes, my lord, select list has been challenged, my lord. So select list challenge before the writ court. Because, my lord, my representation was not decided by the collector. Select list was published and thereafter, my lord, representation was decided. So once, my lord, select list has been, my lord, declared by the authority. My lord, that because during the pendency of writ petition that has been, my lord, part. But once, my lord, the select list has been published, then, my lord, no meaning, my lord, of the that. My lord, they are, my lord, number of persons. My submission is, my lord, if my lord may consider the policy, because except, my lord, district Chhatarpur, other districts have been followed the policy. As per the policy, my lord, the seniority of, my lord, Madhyamik Shikshak would be, my lord, counted with effect from 1/7/2018. That is the date of merger of Madhyamik Shikshak. But upper division teachers are concerned, their seniority would be counted from the date of, my lord, promotion or appointment. So all the Madhyamik Shikshak, my lord, their seniority in all over state, my lord, has been counted with effect from 1/7/2018. And the similar proceeding, my lord.
Well, we have filed a reply. If I could take my lords to one clause of the circular, it mandates that separate. No, my lords, we are not following a different procedure. The fact is that as far as the Madhyamik Shikshak Sambar is concerned, that is middle school teacher, they had no gradation list. So their seniority was reckoned from the date of their appointment. As far as
No, my lord, in initial petition, I was challenging the, my lord, appointee. Subsequently, my lord, the person who are junior. Yes, my lord. My lord, that is my, they are, my lord, because, my lord, this is the, my lord, selection. My lord, may appreciate that is, my lord, they are, my lord, 62 persons, my lord. My lord. Because, my lord, it's a policy matter. If, my lord, my submission, my lord, is correct. They, prior to cancellation, there is. Yes, yes, my lord. Now, my lord, our difficulty is, my lord, they are more than, my lord, 100%, my lord. In first list, 62%, my lord, and in second list, my lord, 27 candidate, my lord. So, my lord, impede them party. Oh, no, my lord, and their service, my lord, my lord, I'll impede party, my lord, the last person, my lord, of the both the list. Because the issue, if, my lord, issue is concerned, my lord, that is not individual, my lord, that is issue involved in the policy itself. Because other district, my lord, have filed, my lord, orders of other district. Yes, yes, my lord. They has to be reverted. They has to be reverted. I'll, my lord, impede party. As well. This matter pertains to appointment on the basis of, my lord, compassionate. The, my lord, this is settled law, my lord, the policy which applicable.
Records are here, the original records.
I'm ready, my lord, to argue. My lord, I'm ready to argue the matter, my lord, because I have most of the record I have filed along with the, my lord, writ petition, my lord. My lord, this is the, my lord, settled law, the policy which applicable on the date of, my lord, employee. That would be, my lord, applied to the, my lord, case of compassionate appointment. Admittedly, the father of the, my lord, appellant was, my lord, died in year 1999. And on that, my lord, particular date, my lord, the policy of 1994 was applicable. And 1994 policy was provided the, my lord, compassionate appointment. 1999 one. At that time, policy of 94, my lord. And 94 policy was, my lord, provided the, my lord, compassionate appointment. Subsequently, in year 2000, my lord, that policy has been, my lord, amended. If my lord may appreciate page 71, this is the policy of 1994 and which was applicable. And authority was admitted, my lord, on the date of father of the appellant. He was entitled, but he was minor.
Lordship, the attention of the petitioner that at the time that his that the policy which was prevailing on the date of death was in 1999. Now at that time he says he was a minor. He moved the first application in 2010. Now, this is the third round of litigation, Your Lordship. In 2010, the representation in 2013, it was rejected on the ground that he's not entitled because by this time, the policy of granting a compassionate appointment to work charge contingency paid establishment employees had been cancelled. So at that time, when the application was moved, that policy was not in force. Subsequently, Your Lordship, he filed a writ petition, and that writ petition was disposed with the direction to consider it on the basis of the similar benefit granted to the private respondent number 6. That was also rejected, Your Lordship, against which he filed the third writ petition, the second writ petition. The second writ petition was again disposed of with a direction to decide it in light of that circular. Now, it is that representation which was rejected and against which he filed this instant petition. So there, in none of the petitions, it was claimed by the petitioner that that policy at the time of date of death should be made applicable to him. His claim was that it should be decided in light of circular dated 28 February 2011. Now, 28 February 2011 provides a cutoff date. Your Lordship, at the time when these applications were rejected, the representations were rejected, there was a full bench decision of this honorable court. Now, Your Lordship, in fact, even that is probably pending before the larger bench before the Honorable Supreme Court. There are judgments which say that subsequently that clarification is there that on the date of death it should be considered. So far as this case. No, it was never considered. In fact, because it arose out of the circular, he never claimed it, and that policy now is not in force, and it was in fact cancelled by a subsequent policy which was passed in the year 2000. Because subsequently they were only granted the work charge contingency paid establishment, the dependents of the work charge, but they were only granted lump sum. Your Lordship, otherwise the law in respect of compassionate appointment is also settled that it is not a normal mode of recruitment. And the penury now has come to an end because it was in the year 1999 that his father died, and subsequently after he attained majority, he filed an application in 2010.
Survived. Zindabad to be survived. Opposite is that is fine. From where competent same argument was British. Very easy just to pass one call of one client come to this court for 10 times. And nobody wants to look at the and spend 2 minutes to give one. Again, who eat me the date. Next one. The upward
1999.
Yeah.
That is in year 2008, my lord.
P5 2010.
10, sorry.
Since then. Policy that. Same.
Cancelled by the, superseded by,
Superseded by
policy dated 1/5/2000. 1/5/2000.
Similar that is from policy. One is required to consider the what is the term in tradition is for the respondents to decide. It's significant. Pursuant to the policy that existed as on date of death.
Hello. Amal.
I pray for a Passover, your lordships.
Should the state is a common party, the transfer order issued by the MP Power Transmission Company Limited. Is a line attendant who's been transferred from Sherdol to Bina.
My lord, I am seeking for 2 weeks time to file rejoinder, my lord. My lord, this is a matter related to recruitment of.
With regard to recruitment of the to the post of assistant professor, they say that they are guest faculty working in the universities and have not been granted weightage marks as is being granted to similarly situated guest faculty in colleges.
Lord, in my case, reply not filed, no. Point 1, Lord. Yes. And my case is also
File a
different, Lord.
reply.
Lord, I pray,
Seeking
Lord,
time notice was
that
issued
my
on the
case
last
is
day.
different, Lord. We have challenged the rule, my lord. There is, my lord, distinction made by the respondent state between the, my lord, guest faculty, my lord. Yes, my lord.
Lord, item number 54 is also similar to 45.
And then two petitions are clubbed in this matter, my lord. The petition number 19276 reply is not filed yet, my lord. Matter is regarding my lord compensation under section in
Yes, my lord.
yes, my lord. My lord, please allow me to say something regarding the matter, my lord. Issue is this that, my lord, when the award has been passed in the year 2015, in the meanwhile, the new act, right to fair compensation, is come into the force, my lord. So my humble submission is this: there were 8 petitions were clubbed in this regarding this matter, my lord. 6 of the petitions were disposed by this honorable court because application under section 34 is pending before the DZ in that petitions, my lord. In these 2 petitions, the issue is still alive, and we do not have anywhere in any other court, my lord. My humble submission is this: that when new act come into the force, in that time the National Highway Act is set apart from that act, my lord. Subsequently, in the year 2015, this act is also come within the purview of new act, my lord. When this act, when the National Highway Act come within the purview of Right to Fair Compensation Act, regarding which Ministry of Road Transport and Highways published and sent before different agencies regarding this acquisition, detailed guideline, my lord. In these guidelines, it is very specifically mentioned that the land acquisition which has been done after 1/1/15 has to be calculated as per Right to Fair Compensation Act, my lord. In the meanwhile, in these guidelines, it is also mentioned if the award has been already passed, but amount has not been disbursed, in that condition, the award should be redetermined, my lord. Please allow me to read. I have filed these guidelines in detail, my lord. Actually, I have argued this matter previously also. My lord has pleased to issue notices, and they have committed that they are going to file the detailed reply, but they are not still filed the reply in this matter, my lord. So my humble submission, if my lord allow me, I can read the detailed guideline under which I have seek this from this honorable court that the award should be redetermined, and I have to be paid the compensation as per the guidelines issued by the Ministry of Roads, Transport and Highways, which are sent by the department, central government, and subsequently in these guidelines, state government has also directions to MPRDC to follow these guidelines and redetermine the award, and the people who are suffering from acquisition are to be paid in the light of new act. If my lord is not convinced, then I may read the relevant part of this these guidelines, my lord. So if they are they want to file reply, let them their reply to be come into the record. No, my lord. Yes, my lord. Yes, my lord. Yes. Please see page number 40 or annexure 2A2 of my petition, my lord. It is the document of State Government of Madhya Pradesh Prati Prabandh Sanchalak, Madhya Pradesh Road Development, Mukhya Abhiyanta, and 3 is Mukhya Abhiyanta, so and so. Land acquisition under the National Highway Act 1956, comprehensive guideline thereon. मध्य संदर्भ भारत सरकार सड़क परिवहन एवं राज्य मार्ग मंत्रालय नई दिल्ली का पत्र क्रमांक सो एंड सो। उपरोक्त विषय के संबंध में भारत सरकार भूमि मुआवजे के संबंधित गाइडलाइन की छाया प्रति आवश्यक कार्यवाही हेतु संलग्न है। Now, page number 49, it is specifically mentioned, this is the annexure of this document, two chief secretaries, the additional chief secretary, the chairman, NHAI, the managing director, subject land acquisition under the National Highway Act 1956 comprehensive guideline thereon. Sir, I am directed to say that the land required for National Highway project is acquired under the provision contained in Section 3 of National Highway Act 1956. Pursuant to the enactment of the RFCT-LA-RR, it is Right to Fair Compensation Act of 2013, and it's coming into force with effect from 1/1/2014. Certain provisions of the 2013 Act become applicable to the other related acts mentioned in the fourth schedule, including the National Act 1956, with effect from 1/1/2015 in term of Section 1053 of RFCT-LA-RR Act 2013, my lord. Point number 4 is applicability of this act to the enactment mentioned in the fourth schedule of the act. I bid. My lord, relevant part is point number 4.6. It is at page number 52. Date of determination of market value of land. Another related but important question is regarding the date on which the market value of land is to be determined in case where land acquisition proceedings had been initiated under the NH Act 1956 and were at different stages as on 13/12/2014. While there is no ambiguity regarding land acquisition proceeding initiated on or after 1/1/2015, this question assumes significance in view of the financial implications in respect of cases where the process of acquisition was at different stages as on 1/1/2015. Section 26 of RFCT-LA-RR Act stipulates that the date for determination of market value shall be the date on which the notification has been issued under Section 11, corresponding to Section 3A of NH Act. Same was the position under the 1894 Act. This is further fortified from the provisions certain in Section 69(2) of RTF Act. As such, it is clarified that the relevant date of determination of market value of land is the date on which notification to Section 3A is published. 3. By now, it is important, my lord, it is also a settled proposition that the first, second, and third schedule of RFCT-LA-RR Act 2013 shall be applicable to the NH Act 1956 with effect from the 1/1/15. As such, the following is clarified. A. All the cases of land acquisition where the award has not been announced under Section 3G of NH Act till 13/12/2014, or where such award has been announced but compensation had not been paid in respect of majority of the land holding under acquisition as on 13/12/2014, the compensation would be payable in accordance with the first schedule of RTF Act 2013. B. In cases where the land acquisition process was initiated and award of compensation under Section 3G had also been announced before 1/1/15, but the full amount of award had not been deposited by the acquiring agency, but with the CALA, the compensation amount would be liable to be determined in accordance with the first schedule with effect from 1/1/2015. C is in cases where the process of acquisition of land stood completed, that is award under Section 3G announced by CALA, amount deposited by the acquiring agency with the CALA, and compensation paid to the landowner in respect of majority of land under acquisition as on or before 13/12/2014, the process would be deemed to have been completed and settled. Such cases would not be reopened. My case come within the purview of clause B, my lord. In my case, award has been passed on 7/6/2016, my lord. In my case, award has been passed on 7/6/2016, my lord. My humble submission is this, that the prayer which may be my prayer which has been conquered by this by respondent on this issue, that I may have to move arbitrator under Section 3G5. My humble submission is this issue has already been settled by Rajasthan High Court because the instructions are for Kala to reopen the case and redetermine the amount. Section 3G5 is very specific. Arbitrator do not have jurisdiction to reassess or redetermine. He can only ascertain the issue within the purview of Arbitration and Conciliation Act, my lord. So my humble submission is that it is the Kala only who has the jurisdiction to decide this issue and to settle the matter in the light of these guidelines, my lords. I have prayed before him number of times. After that, I have sent him legal notice to return my case and disburse the acquisition amount compensation to me as per the law. But all efforts has gone and when. So I am before this honorable court. My humble submission is this issue has already been settled by Rajasthan High Court. The totally identical matter, my lord. Totally identical matter has been decided by Honorable Court of Rajasthan, my lord. May I read the relevant part, my lord? The issue is this petition has been filed by the petitioners with the prayer that the respondent authorities be directed to redetermine the compensation and revise the award dated 2011-2014, my lord. In accordance with the provision of Right to Fair Compensation and Transparency, Land Acquisition, Rehabilitation and Resettlement Act 2013. Brief facts of the case is so and so. And point number 3, learned, it is admitted position that though the award was passed into, my lord, in this matter, award is passed in the year 2014, but amount has not been disbursed. Therefore, the new court order to redetermination and reassess the award. The final verdict of the honorable court is compensation to the petitioner was not paid. May I provide the document? My lord, the concluding para is at page number 16, my lord. As observed earlier, the admitted position is in these cases is that though the award was passed on 2011-2014, but the sanction of compensation amount was received only on 5/1/15, and therefore it is clear that the compensation to the petitioner was not paid on or before 13/12/2014. And in that situation, as per the latest guideline issued by the MORTH, it is Ministry of Road Transport Highway, on 28/12/2017, compensation would be payable to the petitioner in accordance with the first schedule of Acquisition Act 2013. In view of our discussion, the petition are disposed of with direction to the respondent to redetermine the compensation amount awarded to the petitioners and revise the award dated 2011-2014 as per the first schedule of Acquisition Act of 2013 within a period of 3 months from the date of production of certified copy of these awards, my lord. My humble submission, this order has not been challenged before the Supreme Court. So my humble submission is this: in light of the new act, in light of the guidelines issued by the MORTH, and in light of this order of Honorable High Court of Rajasthan, my humble submission is my award is also to be redetermined and reassessed. Yes, my lord. 46.1 is, my lord. Another related this clause, my lord. Another related but important question is regarding date on which the market value is to be determined in cases where land acquisition processing had been initiated under the NH Act and where the different stages as on 31/12/2012, while there is no ambiguity regarding land acquisition proceedings initiated on or after 1/1/15. This question assumes significance in view of the financial implications in respect of cases where the process of acquisition was at different stages as on 1/1/2015. My lord, my submission is this. It was nowhere in the chronology when the new act was not applicable in land acquisition cases under National Highway Act, my lord. Initially, the act has set apart National Highway Act, but by way of ordinance of central government, they include National Highway Act within the purview of right to fair compensation. When 3 ordinances has been passed, after that, the amendment has been done, and the National Highway Act is also come within the purview of this act. So my submission is this: it is nowhere in the timeline of my case. I have not to be, my award has not to be calculated with right to fair compensation act. So far as my case is concerned, the award has been passed in 2016. So I am well within the purview of right to fair compensation act. So they have to pass the order in light of right to fair compensation act as prescribed in first schedule, my lord. That is my submission. This issue, and in light of this guideline, Kala is bound to follow these guidelines. So there is ambiguity and disobedience in his part, my lord. I think that is my humble submission, my lord. Yes.
Original award.
My lord. Yes, my lord. My lord, original award. My lord. Yes. I'm sorry. I'm sorry. My lord, in petition. Yes, my lord. My lord, because my lord, my submission is this: when the original award, the previous award has been passed for my land. In that award, the construction has been left apart. So So my submission is this: when the previous award has been passed, I do not come within the purview of that act. After when the subsequent award has been passed, I come within the purview of that act. So I have to challenge only that part which come within the purview of that award, act, my lord. In my prayer is this, my lord. To issue writ of mandamus for respondent directing them to redetermine and make payment of land compensation award in accordance with the first schedule of right to fair compensation and transparency in land acquisition. I have accepted. I have no other option. If I want to challenge, I can challenge it under section 3G5 before the arbitrator, my lord. My lord, my humble submission is this: that the base amount which is to be challenged before the arbitrator is to be set by the Kala. These guidelines are not for arbitrator. These guidelines are for Kala, and he disobeyed these guidelines. This is my issue. Nothing, my lord. That's all. Yes, ma'am. Very, very patient. I am obliged.
With all respect, my lord, there is one judgment of this honorable court, my lord, I just by dismissing the same writ petition. The court Indore bench. Yes. So we have filed the reply with all respect, ma'am. Yes, ma'am. So grateful.
Obliged.
Reply is available.
But this is a case for grant of compassionate appointment of the merit system. And I pay for time to file the reply.
But on last date of hearing, I sought time to find rejoinder in this case, but after, my lord, perusing the reply of the respondent, my lord, the rejoinder is not necessary. I am ready to argue the matter, my lord. My lord, my lord, the respondent NHI, my lord, constructed the road from the land of, my lord, petitioner. They acquired some land, my lord, but utilized, my lord, excess land of the petitioner. Therefore, he made an application before the Tehsildar for demarcation. My lord, the Tehsildar demarcated the land. They, my lord, acquired 1.084 hectare. 1.084 hectare. I received compensation of this 1.084, my lord. But when I have made application for demarcation before the Tehsildar, after demarcation, it has found, my lord, they have utilized my land, that is 1.332 hectare. 0.24, that is, my lord, excess land, my lord. Then, my lord, I have filed application for removal of the encroachment before the Tehsildar. Tehsildar issued processes, my lord, to the authorities of NHI, my lord. And against that order, my lord, NHI approached to a subdivisional officer who is land acquisition officer, my lord. The subdivisional officer, my lord, directed the Tehsildar to demarcate the area again with the, my lord, authorities of the NHI. If my lord may appreciate, then, my lord, again area has been demarcated But the authorities of NHI who, my lord, present at the time of demarcation, they have not signed the, my lord, said demarcation process, my lord. And Tehsildar has, my lord, mentioned in the demarcation, my lord, report. Area has been demarcated, but RI has stated, if my lord may appreciate page 36, my lord. Then, my lord, I filed writ petition before this court. Earlier writ petition was, my lord, page 30, in which, my lord, they were directed to demarcate the land and how much excess land has been utilized that may be acquired.
We have filed the reply, my lord. He is making a misleading statement before this honorable court. The earlier notification which is being challenged by the petitioner, again challenging the same notification before this honorable court. We categorically stated that on affidavit that your lordship, the road has been constructed on the, your lordship, the acquired land. No surface land and no extra land has been taken. Who has taken it? Secondly, my lord, he is the only person who has been, your lordship, encroached the land of the national highway. We have noticed under section 26. My lord, well, that is wrong. Man. Why I am saying so? Because, my lord, the challenge is made of the notification. Well, we have stated on, my lord, para number 13. Last three line. It is further clarified by the answer that there is no such excess land has been acquired. My lord. Para number 13, my lord, they are challenging notification so and so on the ground of dated so and so has been issued by the Central for acquisition of the land. However, it is clarified by the answer respondent that while later dated so and so on the earlier also, the Tehsildar had demarcated the said acquisition land, and since it has been advised that joint committee has to be constituted for the purpose to end of this case, it is further clarified that the answer is important. There is no such excess land has been acquired. Therefore, the request of the constitutional order even gets final. Lord, what my submission is that, my lord, he has already approached this honorable court on various occasions, my lord, to we have stated, my lord, that extra land has not been taken. We are yes, ma'am. We made a request to the state government to make the inquiry, your lordship, to constitute. We are not worried about that, my lord. But my submission is that, my lord, the road has been constructed on the land which has been acquired. And even though, your lordship, the notification and the notice under section 26 of the National Highway Traffic and Control Road 2002 has been issued into the petitioner, my lord. He has encroached the land, my lord, of the National Highway. Certainly, my lord, certainly. Inquiry may be conducted, my lord.
No, my lord, my submission is, my lord. My lord, I want compensation or they may. My lord. But, my lord, my submission is, my lord, they have constructed the road over the land. My lord. My lord. And they never, and my lord, my lord, they disputed the demarcation, which, my lord, joint demarcation is. That is, my lord, I'm sufficient, my lord, settled. My lord. My lord. My lord. My
हमारी 250 की प्रोसीडिंग चल रही है
It is proceeding suit. Not there. 1.0 notification.
Yes.
That declare
As per the notification. Yes, yes. Madam, notification, my lord. Well, earlier there was some notification. We have not filed it, my lord, before this honorable. But besides this, there was नहीं वो मतलब वो notification is not on it.
My lord, I have not filed notification, my lord.
Pardon? We only said that your lordship be. No, my lord. We are only said that the acquired land which has been notified under the provision of 3A notification.
That is, my lord, 2.248, my lord. Yes, ma'am.
My submission would be. My submission is that.
The excess land ka notification is under challenge.
That is under challenge. That is I am saying, my lord. The excess land, that is
P1
is under challenge. P1, the notification is under challenge, my lord.
But he has come up, you know, in terms of a lordship solving the excess.
0 point, my lord. ये first number है 0.025 hectare. The first page number 13, my lord.
That is some other, my lord, that is another khasra number which is not included in the demarcation process, my lord. My lord, my first, my lord, this is 1079/8. That is, my lord, 1089/1. But the demarcation was done. That is, my lord, page 21.
We will take. No, my lord, I have read out, your lordship. My submission is that the notification under challenge, the subsequently, your lordship, the land which has been exist has been found, that has been notified. No, my lord. No, we said that we say that the excess land is there, my lord. So R says that my lord. I will just clarify, my lord. Next week, my lord, I will just. I will just clarify. I will just clarify by the authorities.
They may also be seen.
Clarified. My lord. No, man. No. Yes, ma'am. Yes, ma'am.
Your submission itself, you want to go and verify.
With all respect, my lord, some complication is there. My lord, I'll just go through, my lord.
His prayer is also same.
Arguing counsel Shri Adisangi is adjusted to. Sledged.
Reply is a bit in this case, my lord.
Well, as the matter pertains to grant of rehabilitation, the matter pertains to grant of rehabilitation compensation to displaced persons of Noradehi Wildlife Sanctuary. The petitioner is a married. I pray for some time to file the reply.
This petition for habeas corpus lordship, respondent number 4 and 5 illegally detained the wife of the petitioner lordship. 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 Lordship, petitioner filed a complaint before the SHO OMTI lordship. On date 27/12/2023 को जब ये मैरिज ऑफिसर के यहाँ गए, वहां से रेस्पोंडेंट नंबर 4 and 5 इन्हें लीगली ले गए लॉर्डशिप। लॉर्डशिप लॉर्डशिप हमने शादी करी है लॉर्डशिप, फादर और ब्रदर के साथ लॉर्डशिप। नहीं, ये नहीं मालूम सर कहाँ ले गए, वो लेके वो गए हैं। लॉर्डशिप इलीगली है सर, उनकी मर्जी के खिलाफ है लॉर्डशिप। जबकि मैरिज हमसे 22/12 को मैरिज हुई है लॉर्डशिप। 27/12 को जब हम वहां मैरिज रजिस्ट्रेशन कराने गए, वहां से वो इलीगली ले गए, फोर्सिबली ले गए लॉर्डशिप, फोर्सफुली ले गए लॉर्डशिप। लॉर्डशिप मैंने कंप्लेंट की है लॉर्डशिप एनेक्सेट, बट पुलिस कोई कार्रवाई नहीं कर रही लॉर्डशिप। अब ये तो कॉर्पस ही बता सकती है लॉर्डशिप। हमने तो पुलिस को भी कंप्लेंट किया है, 155 में भी उन्होंने कंप्लेंट किया, पुलिस कोई भी कार्रवाई नहीं कर रही लॉर्डशिप। पुलिस कोई कार्रवाई नहीं कर रही सर, एसपी को भी जाके बतलाया तो मैंने। लॉर्डशिप corpus is married wife lordship to be a petitioner lordship. Kindly take on next week lordship. लॉर्डशिप मुझे लिबर्टी दे दें लॉर्डशिप, मैं पुलिस में कर दिया लॉर्डशिप, काइंडली लॉर्डशिप।
This is the revision, my lord. We have challenged the order passed by the learned sessions judge, whereby the learned sessions judge has allowed the application of the accused, treating her minor, transferring the matter to the juvenile justice board, my lord. We are challenging the order passed by the learned sessions judge in this criminal revision, that the matter has been transferred to the juvenile justice board, treating her as a minor, my lord. My submission is that the document which has been forged, which is alleged to be forged, has been of 2006. The court has found that it is of 2006 and on that day she was minor. But that document has been used by her in the year 2009, my lord. So the crime has been committed in the year 2009 where she was the adult, major. Therefore, we have challenged this order transferring of the matter to the juvenile justice board, my lord. My lords, I'm so obliged.
May please your lordship. Malus, in fact, the cause list also reflect, Malus, these are the list of other cases wherein the co-accused have challenged the order of the court below, Malus, of framing of charges, and all these matter are clubbed as a bunch.
This is the matter, Malus, that. Well,
Even the cause list reflect this, Malus.
there are as many as 57 accused persons. For Malus, respondent number 1. Both the respondents.
Malus, there is no stay, my lord. I'm only referring this order sheet only for the purpose of.
This is application for discharge has been dismissed at 227 now. That is.
Greatly obliged.
This matter I'm taking for 4 weeks time to file rejoinder. Not recently they have filed a reply. So this is a matter pertains to recruitment of assistant professors, my lord. But in this, my lord, a condition has been incorporated that the benefit of bonus marks will be awarded to the teacher.
Already, the order passed by the learned single judge has been executed, your lordship. We do not wish to prosecute the matter any further.
Yes. Now, this is a challenge to the transfer order. The petitioner, my lords, he was a line attendant. Petitioner was a line attendant class 4 employee, my lords. And by the impugned order, he was transferred from Shahdol to Sagar. My lord, the main ground of challenge was that because he's a class 4 employee, my lord, the 26/6/2020. He is, my lord, he is deported. He is deported, my lord, because there was no interim orders. He has joined, man. My lords, it was at the time of the passing of the impugned order. After that, we have joined.
What do you want?
Man, the distance is more than 300 kilometers. And
That's a big state now. What to do?
if my lords may see the reply filed by them, my lords, because
Could I, my lord? But he is a Group D employee. It's a linesman. Then I'll let him go. The Group D employee, having so my lord, he has been transferred. And when your lordships called upon them to explain, my lords, they filed a reply saying that I was negligent in performance of my duty. My lord, we just have the reply, my lord, therefore the reply. No, my lord, it may not be in the file, but ordinarily Group D employees are not transferred.
Well, that is why, my lord, your lordships called upon them. I had joined, my lord, so there was no question of interim relief at that stage. So, my lord, he has these group D employees mostly remain at the same place. He gets only 36,000 rupees as his emoluments, my lords. With that to be transferred and uprooted and sent 300 kilometers away to a distant place with family is what, my lord, that has been the sequence of judgments that your lordships have passed previously and also by the Supreme Court. Not we. Yes, please. But, my lord, what your lordships have always yes. My lord, may just see the reply, my lord. That is what I wanted to point out. Lord, I.
There is one request, Lordship. Lordship, criminal appeal is pending before the Honorable Court, and the daughter of the applicant is expired, Lordship. Daughter of the applicant is expired. Lordship may be taken after lunch or the temporary bail, Lordship. No, single bail. Yes,